So thank you for joining us this morning. So part two today is looking at the rights of trade union members and issues for employers where they're facing industrial action. And just a quick overview of what we're going to do this morning, what we're going to cover. We'll run for best part of an hour, I think. Stephen will start off in just a moment with the looking at the process of calling industrial action when trade unions seek to do that, and how you might challenge that as the employer. And then similarly look at how the balloting process itself might be challenged as grounds which the employer can try and prevent the industrial action from taking place. My partner will then carry on and look and say, well, who can take part in industrial action, because the position is not as straightforward as one might anticipate. I'll then have a look at the steps that an employer can take in relation to an employee who takes part in industrial action. And also I'll briefly consider some of the employer responses to the trade union. That's in addition to the areas that Stephen will have covered in terms of the call for industrial action and the balloting process. And at the end, I know we've got a couple of questions that have been submitted already, and we'll pick up any questions, assuming that we have time, and hopefully we will. And running through this morning, we're indebted to Will, inventive as ever, who's prepared a scenario for us, which will help highlight some of the points that we will be looking at and talking about. Just a reminder, finally, just the sort of admin piece, it's the usual stuff. If you're having any technical issues, please can you pop any comments in the chat function. If you do have questions as we go along, please pop those in the Q&A in the Q&A box. So Will, I think you're just going to, here we are, run with the scenario initially. Thank you.
Many thanks, Rustin. Good morning, everyone. Trade union law can be fairly technical, so we thought it'd be useful to put together a basic case study, just so we could look at a few examples, just to draw out some of the more technical points and tricky issues. So here is our general background. So we'll refer back to this case study a few times over the course of this morning. So we've got Anton Deck, who is the managing director of I'm a Celeb Limited. The company is a facilities provider offering maintenance, cleaning and catering services. I'm a Celeb has 250 employees, and of those, 100 are employees, and of the employees are members of one union, Snake Rock Trade Union. Another 100 are members of a different union, Croc Creek. And then the remaining 50 employees are not members of any trade union. I should just add, before I pass on to Stephen, that the details in the scenario are purely fictional, and any similarities with real life are purely coincidental. So with that, I'll pass over to Stephen.
Thank you very much, Will. I'm going to look at the question of challenging the call for industrial action. So if we go on to the next slide. I'm looking at employers' rights against trade unions only, not against employees who are taking industrial action. That will be dealt with by Rustin later. And in English law, industrial action is usually described as a privilege, not a right. So there's no constitutional right, as there are in many European countries, to strike, which means that if you go on strike or you propose industrial action, that industrial action will be unlawful unless it's taken in accordance with the law. So this is usually the law as set out in the Trade Union and Labour Relations Consolidation Act 1992, called so-called TOLCRA. So the way I think to look at the options you have as an employer against a trade union is to look in detail at the rules themselves, because unless the industrial action is taken in accordance with those rules, it will be unlawful. And in a sense, industrial action is always unlawful because employees taking part in industrial action do so in breach of their contracts of employment. They're obliged to provide their services in return for pay, and they are withdrawing their services. A trade union authorising or endorsing industrial action also breaks the law by inducing their members to breach their contracts of employment by not offering their services. So the breach or the inducement by the trade union remains unlawful. The way the law in England and Wales works is that the employer cannot take legal action against the trade union as long as the trade union has fulfilled the necessary conditions for a lawful industrial action. If they don't do so, action can be taken against them. So it might be useful to begin by asking, what is the definition of industrial action? And there isn't one. The Court of Appeal has said that it's a refusal of employees to do anything as a bargaining weapon, which I don't think is particularly useful. But there are two basic forms of industrial action. There's most obviously the strike, but there are other forms of industrial action, such as overtime bans, work to rule, and go slow. And these are industrial action because the employees withhold services that they normally withhold, but fall short of actually withdrawing their services altogether. And that too counts as industrial action. So looking at what trade unions have to do in order to take part in lawful industrial action, one should ask 5 questions, I think, to put it in its broadest terms. The first is, does the industrial action involve a breach of contract by the employees, and has the trade union induced it? Because if there is no breach of contract, then there's no industrial action in this sense. The second question, has the union authorized and endorsed the industrial action? Or if it has it later repudiated the industrial action? If the union hasn't authorized or endorsed, then it isn't liable. Question 3, is the industrial action in furtherance of a trade dispute or not? Question 4, is the industrial action in furtherance of a prohibited reason? Because if it is and is otherwise lawful, it'll be unlawful. Question 5, most importantly, have the balloting and notice provisions been complied with by the trade union? So let's have a look at those in a little bit more detail. The first question, and really the most obvious, but one often not asked, is the proposed industrial action in breach of the employee's contract of employment at all? Going on strike, as I said, will be a breach because it withdraws the employee's labour that it promises under the contract, but other industrial action really depends. The key thing is whether the employees are withdrawing services that they are promised to undertake under the term of the contract. And note, as we all know, there are both express terms of contracts and implied terms. And what was once a matter of conduct between the parties can harden into a contractual term. Why is this important? Because if there's no breach, then you can take no action against the trade union, as I've said. Why? Because there's no breach of contract which the trade union has induced by calling on the action that it does. And there's a lovely example of this called the Ministry of Justice against the Prison Officers Association, where the members were instructed by the union not to do voluntary things that they were doing, but they were also crucially voluntary things that they were not obliged to continue doing if they decided not to do them, if that's not too unclear. So if we go over onto the next slide, an interesting question arises about collective agreements. What if your collective agreement with your union forbids industrial action? Well, the answer to that is because collective agreements are not generally legally enforceable contracts, the union won't be bound by it unless they contractually and expressly agree to be bound by it. So a collective agreement is usually irrelevant in looking at this question. So here's Will's first scenario, just to draw this idea out a little bit. I'm a Celeb offers pest control services to clients, removing cockroaches, spiders, rats, etc. It's an important offering. Many clients wouldn't engage their services without this element. And as you can see, it's pretty grim. The requirements to do this work are not contained in the employee's job description. Employees do the work on a voluntary basis. And due to the unpleasant nature of it, as we've seen from the photograph, they're offered double pay for undertaking those duties. Following a review, Anton Deck decides that the extra pay should be cut from twice to 1.5 times only. The employees are very unhappy about this. Snake Rock, the union, speaks to its members and instructs them all to decline to take part in cockroach, spider or rat removal. Without them, I'm a Celeb won't be able to provide the required level of service. So is this a voluntary thing that the employees have undertaken to do, or in the sense that we saw with the Ministry of Justice case, or is there a contractual breach here, or are they withdrawing their services in a different way? I think here, on balance, I would say that they have undertaken to do these services, they do them regularly, they're well paid to do them, and that if the union decides to take action over this and to withdraw from these services, particularly one that's so important to I'm a celeb, then it probably is industrial action and it probably is a breach of contract. But you can see that if the terms are slightly different and they're not obliged to do these services or can withdraw from them at any time, and the contract says that, then it may be that there is no breach of contract, and therefore the union is not liable when it speaks to its members and asks them to withdraw their labour in this particular case. So, second question, has the trade union endorsed or authorised the industrial action? If it hasn't, then no legal action against the trade union is possible. The union can authorise or endorse industrial action through a number of different means, and this is by no means the complete list. It can authorise through its executive committee, its general secretary, any official of the union, and crucially, any union's shop steward. I say crucially because the shop steward is most unlikely to be a full-time official of the union. They're likely to be an employee of the employer. So they're likely to be able to bind the union in a way that is much more direct and quick than the union can itself. If unions authorise or endorse strike action, they may also repudiate it. So the union may decide it doesn't wish to continue to authorise strike action, and it formally repudiates it. If it does so, it's not liable after it repudiates. And you often hear in the media discussions about official and unofficial industrial action. The difference is that official industrial action is endorsed or authorised by the trade union. Unofficial action is not. The third question, is the industrial action in contemplation of a trade dispute? The so-called golden formula, which is now about 120 years old. If it has nothing to do with a trade dispute, which is an extremely wide definition, then the trade union won't have immunity from legal claims from the employer. If it is, then it potentially does have. The fourth question is the industrial action for a prohibited reason? Because if it is, and the union applies by all the other rules, it'll be unlawful. So if you strike to enforce a closed shop, to support employees dismissed in unofficial action, in support of secondary action, to compel an employer to incorporate in supplier contracts the use of specific union members, or to underline support of properly organised ballots, then it'll be unlawful. And as I said, there's quite a long list of unlawful prohibited reasons, and this is just a sample of them. So it's quite an important question to ask. But the fifth and most important question is, has the trade union complied with its notification and balloting obligations? And this I'm going to have as a separate section of my talk, because I think it's the most important, the most detailed section, and the most likely area where the trade union will slip up, to put it bluntly. So moving on swiftly, here is the balloting process. The ballot is, as I said, the ballot is usually where the trade union is most vulnerable to employer action. It's important for the trade union to get it right. The balloting rules are complex, and there's a huge amount of case law on this, but I think it can be very briefly stated as, although perfection is not required when complying with the rules, near perfection often is. So it's very easy for trade unions to fall outside these rules. The first thing you have to do is to notify that a ballot is going to take place. You notify the employer. You must notify the employer of any employees who are entitled to vote. You must do so 7 days before the ballot, and a copy of the voting paper must be given to the employers and to the employees 3 days beforehand. If more than 50 members are entitled to vote, the trade union has to use an independent scrutineer to run the ballot. Arrangements for the ballot: all those entitled to vote must be given the opportunity to vote, but note, trade union members only may vote, nobody else may, even if they're caught up in industrial action. And those taking part in industrial action are not necessarily those who are going to withdraw their labour in breach of contract. All taking part are entitled to vote, and the union has to get this right. The required turnout for all ballots is at least 50% of those who are entitled to vote must be shown to have done so. So if you have 1,000 trade union members, at least 500 need to vote. If they do, then a simple majority is enough, so 251. And by the way, those who are entitled to vote include those who spoil their ballot papers. But there's a difference in important public services. In addition to the 50% above, at least 40% of those entitled to vote must have voted in favour of strike action. So, repeating the scenario above, 1,000 are entitled to vote, 500 must vote, but if only 500 vote, then 400 of those, 80% of them, must vote for industrial action. If they don't, then they can't lawfully go on strike. Once the ballot has taken place, the trade union must inform those entitled to vote of the ballot and the employer of the result. The employer includes any employer of any person entitled to vote. The announcement is prescribed. It has to set out the number of votes cast, the numbers of yes and no votes, and the number of spoiled ballot papers. And the timing of the announcement is both important and a little vague. It's as soon as is reasonably practicable. And in one case, the court granted an injunction to an employer preventing a strike when there was a delay of simply 24 hours in the union informing the employer of the result. A couple of other points to note. Even if the ballot is valid, it lasts for only 6 months. So you can't have a ballot in January for a strike in August, unless you extend it to 9 months with agreement between the union and the employer. But it seems to me that's quite unlikely. If the members vote for industrial action, notice of the industrial action must be given to the employer at least 14 days before the industrial action takes place. A ballot can't be carried out retrospectively. You can't go on strike and then have a ballot afterwards, however well run the ballot is. And multi-strike sites, where you decide to strike over a number of different sites, with a few and complicated exceptions, only one employer and one workplace may be balloted at once. So those are the points. If the union is in breach of its obligations, what are your legal remedies? Rustam is going to go into this in a little bit more detail later on in this talk, but very briefly, if the trade union is in breach of any of the legal requirements, the strike will be unlawful, and the employer can apply to court for an injunction to prevent the strike from taking place. Rustam will deal in a little bit more detail with the precise way in which the court orders the strike to cease. But it's an immediate remedy. Once you've got an injunction and served it on the union, the strike is at an end. But what happens if the strike has already taken place and you suffer damage? Well, you also have a remedy for damages. But note, damages are capped, and they're capped reflecting the size of the membership of the union. If you have fewer than 5,000 members, the maximum damages you can obtain as an employer is £40,000. And there's a sliding scale up to those trade unions with 100,000 members or more. The damages you can recover from them are capped at £1 million. And incidentally, this damage cap was quadrupled on the 21st of July this year. So injunction is the key remedy, and this is well illustrated by the famous Gate Gourmet airline food strike a few years ago, which rumour hath it cost the employer about £1 million a day, but its damages were capped at £250,000 in total. And that's despite the fact that it's successfully brought legal action against the union. So I hope that's helpful. And I've zipped through a lot of law very quickly, as is often the case in these talks. I'm now going to hand over to Will to look at the other side from the employees who can take part in any industrial action.
Many thanks, Stephen. So Stephen's talked us through about how industrial action can be arranged, but then it obviously begs the crucial question for employers about who in your workforce can actually take part. So in terms of your employees, who can take part? Well, first of all, members of the trade union who are authorising or endorsing the action can take part. Members of other trade unions can also take part. And then thirdly, non-union members can take part. So in fact, any of your employees can take part in industrial action. So far so good, seems fairly simple, but as always with these things, it becomes a lot more complicated, because even though someone can take part, the particular how their industrial action for them will be classified, which in turn, say Rustin will explain in a bit more detail later about what an employer can and can't do in respect of its employees, and that will depend on whether the industrial action for that individual is treated as official, unofficial, and indeed whether it's what we call protected. So say Rustin will go into a bit more detail on that, but just to give you a quick overview of what it means in terms of being official, unofficial, and protected, and when and who will fall into what category. For official trade union action, then it needs to be under one of three categories for it to be treated that way. So the first category there is an employee involved in the industrial action is a trade union member and their own trade union has authorised or endorsed that particular industrial action. So that's fairly straightforward. If their own union is endorsing it, then for that employee, then it is official or treated as official. The second category covers employees who are not trade union members at all, so they're members of no union. However, as long as at least some members of the trade union who has authorised or endorsed the action are also taking part, then their protection, the same protection, extends to employees who are non-members in exactly the same way. However, it doesn't extend to members of other unions who haven't authorised or endorsed the action. And then the third category of what's treated as official is where the employee is not a trade union member, but no one else involved in the industrial action are members either of any union. So in that third category, although strictly speaking, you haven't got a situation where a trade union has authorised or endorsed it, that insofar as they're not trade union members, they are still treated in the same way in that particular circumstances. Those employees, they will be treated exactly the same way as if it were official trade union action. So by default, that's what official is. So unofficial is any action that doesn't fall into one of those three categories. So the obvious examples would be a scenario where someone is a member of a union that hasn't authorised or endorsed the action. For them, it will not be official. And again, looking at that third category, the employees where none of the employees are trade union members, of course, if you end up with a mixture so that some non-members become involved as well, then again, it will turn that into unofficial action. And then the final concept just to run past is what we call protected. Again, as I say, Rustin will explain in more detail what it means to be protected from an employee perspective, but effectively it will be protected where it's officially and lawfully organised by the trade union. So following the process that Stephen has just run through, if that has happened, then the protection for the trade union members will be protected. And indeed, in that second category in the official list, again, that protection will also extend to non-members in those circumstances as well. So just to go through it once more in terms of the different categories of employees, first couple are straightforward. So for trade union members, if their own union has authorised and endorsed the action, for them, industrial action will always be official. It will also always be protected, provided that it's been lawfully organised following the correct balloting process. Members of other unions, so you can have action that's endorsed or authorised by more than one union, but for people who are members of the unions that haven't authorised or endorsed it, again, it's straightforward. For them, it will always be unofficial and it will never be protected either. So the one that gets more complicated, of course, are the employees who are not members. So for them, it very much depends on who else takes part. So in the first category, if members of the union that did authorise it have also taken part and it was lawfully organised, then for the wider category of non-member employees, it is treated as official and protected. Conversely, if no one taking part is a trade union member of any union at all, then the industrial action is treated as official but not protected. So effectively in the same way for the union members as if their own union had authorised it, but they hadn't followed the balloting process. Official but not protected. And then the third category, if the participants in the industrial action are the non-members plus members of a different union and no members of the union that did authorise it, then the industrial action is both unofficial and not protected. So just to draw that out a little bit further, obviously the next issue, of course, is, well, okay, so we know who can take part, but what does taking part actually mean? That's obviously an important factor. Sometimes it's very obvious, sometimes less so. There's no statutory definition of taking part in industrial action, so we have to look at the case law. And what that's established is that when it comes to the question of whether an employee is taking part in industrial action, it becomes a question of fact. You know, what is the employee actually doing? What do their activities look like? And that's how it's assessed. Employees are judged by what they do. Case law has also established that motives aren't important. So it's not why someone's chosen to do the things that they're doing, or, you know, for example, fear of threats, for example, in background. It's about what they actually do that's all important. Case law has also established separately to what they're actually doing on the day of the industrial action. An employee will be treated as taking part in industrial action at the point they tell their employer of their intention, as long as that is specific. So in other words, if an employee says, I intend to take part in this industrial action on this date, on my next working day, for example, is specific, in those cases, they will be treated as being involved in taking part. However, a general threat to take part on an unspecified future date doesn't count. So the courts have established that. It needs to be specific. They need to tell the employer exactly what they intend to do and when for it to be classified as taking part. And then, of course, together with their actual actions as well. Once someone has started to take part, they can stop. But that will only be where either the industrial action has been officially called off, so no one is taking part anymore, or the employee tells their employer that they're no longer taking part and through their actions they actually return to their job, or indeed, even if they don't tell their employer, if they just return to their normal work, then again, as a question of fact, they're no longer taking part. Where it gets complicated, of course, or in some cases, is if someone's absent from work on different grounds. There might be strike action, for example, but you might have employees who are on annual leave, they might be on sick leave. And it becomes very easy for an employer to fall into a trap of thinking that that particular group of employees who are intending to be taking industrial action, the employees haven't turned up to work. It's assumed that everyone's involved, but not necessarily so. It might be that someone wasn't taking part because they were absent for other reasons. Conversely, just because someone was technically meant to be off on that day for other reasons doesn't mean they can't take part. And again, it becomes a question of fact. So drawing that out in terms of going back to our scenario, just look at an example. So Ant and Dec announces that a large-scale redundancy exercise is going to take place. They're told that employees are going to be evicted from the business in batches to be selected and announced on a daily basis in the coming weeks. However, at the same time, new seasonal workers are brought in to cover the duties of those who could be made redundant. Naturally, the staff are particularly upset about the fact that they are at risk of redundancy while other people are being brought in. So they decide to, a number of them decide to gather around the fire pit in the central courtyard and refuse to go out to undertake any of their duties. None of the employees involved in this are trade union members. Matt is a member of Croc Creek, and Croc Creek has not authorised or endorsed this particular action. Matt's currently off sick after eating something particularly unpalatable in the work canteen. Matt's a newcomer to the business. He's really worried about his popularity and whether his popularity or lack of puts him at particular risk of being picked for redundancy. He thinks it's going to help if he shows some solidarity with his work colleagues, so he drags himself out of his sick bed and joins them at the fire pit. Ant and Dec head to the fire pit and they tell everyone gathered there that they're considered to be taking part in an industrial action because they're sat around, they're refusing to undertake their duties. And they're told there'll be consequences for those who do not leave the fire pit. All of them stay put, none of them leave. So a question for you, a quick poll question. In these circumstances, Matt's off sick, but he comes and sits down at the fire pit with his colleagues. They're all told that if they don't leave, they're treated as being involved in industrial action, but they all stay put, including Matt. What do we think? Is Matt taking part in the industrial action? Let's have a quick vote, just a straight yes or no answer. So gut feeling is Matt taking part? He's off sick, so he wouldn't have been working anyway, but he's sat there with his colleagues in the same way as them. Just take a moment for the results to come in. We're going to have a separate vote maybe later about whether Matt should be evicted, but that's a separate matter. Okay, so we've got fairly strong things, 80% in favour of yes. Again, it's not a straightforward matter, of course. Though it does very much depend on facts. It's a tricky one. Obviously, he was never going to be working anyway. However, if we just move on to the next slide, say taking part in industrial action is a question of fact, and motivation is not a factor. So just because he's worried about whether he might or might not be made redundant, worried about his popularity, what his colleagues will think of him, that's completely irrelevant. It's all assessed on what he actually does. In this particular case, in fact, it's very, very similar to the Gate Gourmet case that Stephen mentioned earlier on. And this is exactly what happened, that someone was meant to be absent. They turn up in the staff canteen. Those in the canteen were told that they were taking part in industrial action, were told to leave. They didn't. And the court decided that the individual who was not meant to be at work that day anyway, because he had basically taken part in the same way as everyone else in terms of sitting put in the canteen, in the Gate Gourmet case, he was treated as taking part in the industrial action. So I think exactly the same is going to happen here with Matt. He was sat down the fire pit. He was protesting in the same way as his colleagues. So chances are almost certainly he would be treated as taking part in the industrial action. And of course, just going back to the first part of this section, the consequences of that are potentially quite important, because up to the point of Matt's involvement, everyone taking part was a non-trade union member. So 100% of them attending were non-members, which you will remember therefore means that they fall into that category, that they would be treated in the same way as if it was official industrial action. Albeit not with the high level of protection, but nevertheless official trade union action. Matt's involvement, he is a member of a trade union, and his trade union has not endorsed the action either. So he's now contaminated the pool basically, and his involvement now turns the action for everyone there involved from official to unofficial. And again, Rustin will explain the significance of that in just a moment. So on that note, I will now, with Matt having ruined it for everyone, of course, I will pass over to Rustin.
Thank you, Will, and indeed, Stephen. And Will, as ever, indebted to you for your ingenuity. So I'm going to, as Will says, look at the lawful action that can be taken in relation to an employee who's taking part in industrial action. Well, Just taking a step back, the employer's responses, or the employer's potential responses to employees taking industrial action, are broadly speaking threefold. The first is that the employer may be able to withhold pay. The second is that the employer may be able to take some other form of action against the employee, perhaps less than dismissal, but something else. And the third is indeed that the employer may seek to terminate the contract of employment and dismiss the employee. And just briefly, while we're on this slide, just to flag, at the same time, Stephen referred to the limits in terms of the amounts that employers could recover from trade unions. At the same time as those changes were brought in, many of you will probably be aware that there was a lot of bang drumming by the government, and they changed the rules about the use of agency workers. Previously, for a variety of historical reasons, it had been viewed that it would be inappropriate and effectively unlawful, and indeed a criminal offence, for an agency to provide workers as effectively strike breakers in place of those employees. And what happened in the summer was that prohibition essentially was removed. So it's now possible to use an agency to supply staff, but as the government, I think, has immediately found, for instance, in relation to the dispute on the railways, and today, of course, we've got, I think, still strike on the tube in London, that unless you have a ready supply of trained, competent, knowledgeable staff to actually fulfill the roles, then obviously simply being able to say that, well, I can go to an agency to get staff won't help. So looking at the employer's responses, the first is the possibility of withholding pay. Well, as Stephen has said, the strike action is indeed a fundamental breach of contract by the employee, and that entitles the employer to withhold pay for every period, every day of strike action. Say every period because, for instance, in the context of hourly paid staff, it's quite easy and straightforward to work out how to do that calculation. With salaried staff, it's a little bit more difficult. There's something called the Apportionment Act that dates back to 1870, which broadly speaking says that under a contract where there's an entitlement or liability to make payment over a year, that the liability to make that payment is deemed to fall equally between each day of the year. So in other words, 1/365th or 1/366th in a leap year. However, there's also a fair amount of case law which tends to suggest that in most, but not all cases of salaried staff, the correct deduction would be 1/260th of base salary. So there's a slightly tricky point for employers just to work out what is the correct amount that they should withhold for somebody who is a salaried employee who is taking strike action. However, that was strike action. What if the action is short of a strike? And Stephen and Will have both, I'm not sure I'm up to cockroaches at this time in the morning, but anyway, they've given examples perhaps of where the action might be short of a strike. Well, as Stephen said, it's an important consideration. Is it a breach of contract? And if it is, it may be that the employer is able to say, well, actually, what you, the employer, are doing is you're not performing the whole contract, you're only part performing the contract. And in that context, the employer has a choice. They can either refuse to accept the part performance altogether and say, well, if you're not going to do everything you're supposed to do, go away and go home. I'm not paying you at all. Or they can accept the part performance, but make clear that they're going to make a proportionate reduction to the amount of pay. Now, where the employer makes a deduction in that context, the employee's remedy, if they want to challenge either the fact of the deduction or to say, well, the amount deducted is not correct, is not an unlawful deductions claim, as perhaps one might think. It's a claim for breach of contract in the county court. And the reason for that is the statutory scheme around unlawful deductions expressly doesn't apply in the situation where the employee is already themselves in breach of contract by taking industrial action of one form or another. Now, the other action short of dismissal by the employer, the legal position here, unfortunately, is somewhat confused. Can the employer, for instance, threaten to withdraw future benefits or opportunities from the employee? Can they say, well, look, if you're taking part in this industrial action, don't expect to get sent on that training course anytime soon. And of course, the training course might be very helpful. It might enable the employee to progress their careers. It might enable them to secure overtime at enhanced rates or whatever it might be. So can they, for instance, to do that? Well, the argument in favour is that there's no express protection. And I know this is a little bit like, well, it's almost proving a negative, but there's no express protection in the context of other action short of dismissal by the employer, where there is clear statutory protection in certain circumstances. I'll come on to that in just a moment, where the employee is taking strike action and the employer seeks to dismiss. There are certain circumstances where the employee is protected. And the fact that there's no statutory scheme in that regard, one might say, well, that means the employer has got a fair hand, to essentially a free hand to do what they want. The counter argument to that is, obviously, all of us as employment lawyers and HR practitioners will know that the contract of employment contains this implied term of mutual trust and confidence. And of course, saying to somebody, well, basically, I'm going to make life difficult for you. I'm going to withhold something that you might otherwise have expected as a continuing employee of mine. And I'm going to do it to you for this reason. It might be said, it might be argued that it's a breach of the implied term of trust and confidence for the employer to refuse or withdraw or seek to exercise its discretion in a particular way, for instance, as regard training opportunities. So I'm afraid on this point, it's not altogether clear. If we then look at termination by the employer, well, there is some limited statutory protection for striking employees. Sorry, the against there is probably a rogue against. There is some statutory protection for employees, but it's also important that the employer treads with care to avoid, frankly, expensive unfair dismissal claims. I'll come on to reasons for that in a moment, but a couple of them just to remember. There is no qualifying period for a claim of unfair dismissal where it's in relation to strike action or indeed industrial actions. There's no 2-year service requirement. Second point, just to remember procedurally, is rather than the usual 3-month time limit to bring a claim of unfair dismissal, it's a 6-month time limit. And the other, as we'll see in just a moment, is that the way in which tribunals approach compensation or the remedy, it tends to be a little bit different in cases of unfairly dismissed employees taking part in strike action. When we're looking at this, essentially, as Will's outlined already, there are a number of different scenarios, and essentially there are 5 likely scenarios. The first might be termination by the employer, and that's essentially where the employer locks out the employees. The employees are very clear that we're not going to turn up for work tomorrow. That's very clearly communicated, and the employer says, well, you know, stuff that for a game of soldiers, you're not coming in. So they literally lock the metaphorical gates and prevent, effectively, even if the employee wanted to, the employee coming in to work. Well, of course, there, the employer is saying, well, I've done this, and that's just recognising that you already have said that you are going to breach your contract, fundamentally breach your contract of employment by not coming in. Now, in this context, providing all strikers are dismissed, and the employer then doesn't selectively re-engage some of the strikers within a period of 3 months, the employee cannot claim unfair dismissal. And that's Henry just joining in, for those of you listening. The second scenario is where there's termination by the employer and strike action has not been authorised or endorsed by the trade union. Well, where the action is taken only by trade union members or by a mixture of members and non-members, the action is treated as unofficial. And in that context, a dismissed employee has no right to claim unfair dismissal unless certain exceptions apply. And when we say no right to claim unfair dismissal, it's not that the hearing goes sort of full bore and the tribunal says, well, they were dismissed and is it a fair or unfair dismissal? The tribunal does not have jurisdiction to consider a claim of unfair dismissal in those circumstances. So it's a little bit like where sometimes we're arguing jurisdiction that perhaps the employee hasn't had 2 years service in an ordinary unfair dismissal case. So you don't get to the full merits, as it were, of the hearing. Now, the next scenario is where none of those who are on strike are in fact members of the trade union that's called the strike action. Well, as we'll outline, this strike action will be considered unprotected. I mean, strictly neither official nor unofficial, because none of them are members of the trade union. And in that context, there'll be no right to claim unfair dismissal unless the employer has been dismissing selectively. So in other words, this is, if you like, almost the ordinary common law position. So you're supposed to turn up to work, you don't turn up to work because you say you're taking industrial action. The employer says that's a fundamental breach of contract by you. And what basically the law says is, because you're in that fundamental breach of contract, you don't have a right to claim that you've been unfairly dismissed. But it's really important to appreciate this point about selective re-engagement. And it's the thing that, frankly, catches out employers so very often, because they say, oh, well, we will have so-and-so back or such and such back because they're not so difficult or they're not so problematic. And the difficulty there is, if you selectively re-engage in that way, then you do bestow unfair dismissal rights on all of the others who've been dismissed. Now, the next category is where the trade union has called for action, but the balloting process has been defective. And this was obviously one of the examples that Stephen was talking about earlier on. So here, of course, it's official action because the trade union is saying, well, we're calling it and we're doing it and we want you to do it, but it's unprotected because the trade union hasn't jumped through the hoops, it hasn't ticked the boxes. Now, in that context, the individual who's dismissed has no right to claim unfair dismissal, again, unless in this context, the picking and choosing is around the dismissing. So if the employer only dismisses some of those taking strike action, then all will have the right to claim unfair dismissal. But as long as the employer doesn't do that, none of them will have the right. And just, we don't need to go back to the previous slide, but just making the point that was on the bottom of that previous slide, you have the issue that in that context, the trade union won't necessarily have protection. Finally, we've got the termination by the employer. And this is where official action has been called. It's been lawfully organised by the trade union. They've got the balloting right. They've done the notification correctly. And the immunity, the trade union immunity from suit that Stephen has been talking about this session and last, that immunity has been retained. Well, in this context, unfair dismissal protection applies if the dismissal occurs either within the protected period, that's within the first 12 weeks from the first day of strike action, or after the end of the protected period, but the employee has by that time ceased to participate in the strike action or did so before the end of the period, or after the end of the protected period, but where the employer had failed to take the steps set out in section 238A of TULCRA, which is, it's a slightly odd section, Tree, because you don't usually see a section saying this is how an employer is expected to behave. But basically it sets out the sorts of, well, not the sorts of steps, these steps which the employer is expected to have undertaken in order to resolve the dispute. So in other words, in order to have the benefit of this protection, the employer has to show that it has legitimately tried to settle the dispute and has been unable to do so. And therefore, the employees potentially lose the protection. But if the employer hasn't done its bit, then the dismissed employees will have unfair dismissal protection. Now, what does that mean? Well, it's the remedy point. And touched on this very briefly, but I think our experience is in those cases where striking employees are dismissed, where they have unfair dismissal protection, and it's held that they've been unfairly dismissed, an employment tribunal will overwhelmingly look to consider the remedy of reinstatement and re-engagement. Now, everybody knows, or everybody should know, that in fact it's always the tribunal's statutory duty in the case of an unfair dismissal to consider reinstatement and re-engagement as the first potential remedy. But I think we also know from general experience in ordinary unfair dismissal claims that in practice, the tribunal very quickly gets to the compensation element. But in these cases, it's, I think, a relatively well-worn principle that unless the employee has done something else which warrants and merits their dismissal, they're likely to be reinstated. The point just about the compensatory award is just a reminder about section 124.3, which does allow, people often say, well, there's a maximum to the compensatory award. Well, there is, but there's also this provision that people often overlook that allows that cap to be lifted in certain circumstances. And the other point just to appreciate is when employers try and argue for contributory fault, simply going on strike action, if the dismissal is unfair, the strike action will not be considered to be contributory fault. And bear blameworthy conduct by the employee to reduce the amount of compensation. Touched earlier on the use of agency staff and whether that's a false hope. I mean, it's all, the employer's always been able to hire new staff to cover for striking employees. That hasn't changed. I mean, obviously, it's very difficult, both practically and from an employee relations point of view. I mean, how to make a bad situation worse is probably going and bringing in new staff. That historic prohibition on the use of agency staff, it was effectively swept away in the summer of this year. But there are those practical issues that I referred to about technical competence training and safety. And just to flag in terms of what's in the news, there's a judicial review challenge by the TUC to those regulations. And it says there in opposition by the REC, that's the obviously the Confederation for Recruiters and Agencies, that the opposition is not actually opposition to the TUC. It's many agencies are saying, actually, this is really unhelpful. We don't want to end up caught in the middle with the staff that we supply, effectively getting the very sort of sharp end of criticism and potential, obviously, unpleasantness and intimidation from striking employees. So it's one of those bits of legislation which, as I say, often politically it makes a lot of noise. Whether it makes a lot of difference, one doesn't know, but there's also a challenge ongoing around it. And then finally, just briefly looking at employer responses to the trade union in some of the circumstances we've been talking about earlier. Well, first of all, Stephen touched on injunctions. Well, the trade union, if the court is prepared to do so, can grant an injunction that requires the trade union to take steps so that no further inducement, and we always talk about inducement in the context of strike action, trade unions, inducement of the individuals to take part in the industrial action, and that no person engages in conduct after the injunction has been granted because of the prior inducement. However, it's also very important to appreciate that the court will not, in fact, never grant an injunction in terms that requires the employee to attend for work. Now, the tactics and timing around seeking injunctions are often key considerations. They're very often obviously applied for in a tremendous hurry. By their very nature, you're trying to stop something from happening within a short time scale and window. Now, if an injunction is granted, the failure by the trade union to observe its terms can amount to contempt of court. And obviously that is taken very seriously. That can give rise on a sort of increasing scale, I suppose, from a fine to the sequestration of assets of the trade union and or imprisonment of individuals. Just briefly on the criminal liabilities. Now, it'll be rare for employers to seek to bring a private prosecution and to use the criminal law in that way. But of course, the employer may be able to use the mechanisms, as it were, the organs of the state to try and discourage, dissuade, or remove those who are taking part in, for instance, picketing. I'll come on to that in a moment. Now, very few employees are actually prohibited by law from striking. Those in the armed forces are, those in the police are, and the prison officers have they're sort of an interim category, but broadly speaking, around a no strike, or what might be termed a no strike agreement. Now, the criminal law in this area has largely been codified over the years, particularly in the Public Order Act in 1986, which introduced formal statutory definitions of crimes of riot, violent disorder, etc. And in the context of strike action, industrial action, probably be fear or provocation of violence, possibly causing harassment, alarm, or distress. If we then jump down this further in the Criminal Justice and Public Order Act, criminal offence of intentional harassment. Now, Section 220 of TULCRA, the 1992 legislation that Stephen had referred to previously, expressly permits peaceful picketing, but it is tightly prescribed. And the key is the peaceful element. Now, there's a detailed ACAS code of practice on picketing, which again doesn't formally have legal force as a freestanding document, but courts and tribunals are required to have regard to it. And what's really important here is the activities while picketing may constitute a criminal offence. And if they do, that is not peaceful picketing. So that, again, becomes unlawful. And the classic ones there are obstruction of the highway or breach of the peace. That's obviously at the lower end. Clearly, if it's violent disorder, you're moving up the scale. And just briefly, Section 240 and 241 of TULCRA, provides some specific criminal offences and sanctions of imprisonment in certain circumstances where one could see in extremely inflamed and fractious strike action where those provisions might apply. So how are we doing on time? We're just after 25 past. We've got a couple of minutes left. Just on questions. I think we had, did we have one earlier on, Will, about strike action picketing and remote working?
Yes, we had a question. The question asked was whether there was such thing as you have a virtual picketing line. So that for remote workers, obviously more common this day and age. So people working remotely, can you have a virtual picket line? Was the question.
Yeah, I think the answer to that one, I mean, looking at both at the legislation and the codes of practice, is that they haven't quite caught up with dispersed and remote working. I guess that would be the first point to make. But having said that, the provisions talk about being able to picket at your normal place of work. So, I mean, you could stand out, I suppose, I could go out and stand outside my own front door and say that was some sort of virtual picket line. But of course, the issue of the picket line is partly to dissuade and discourage those from crossing the picket line and going in. So somebody can't come to somebody else's place of work and picket. You could notionally, I mean, flipping it around a little bit, if there is provision that says that if you are working on a dispersed and remote basis, that you can go and picket at the place where your work is organised from. But I think that's not the scenario I think that's being asked about in the question, which is really whether somebody can come and stand up outside my front door, to which the answer essentially is no. But whether one person standing on their own would be enough. Stephen, was there something you wanted to add?
An alternative way of looking at the question is whether you can actually interfere with the computer interface between you and your employer in some way, in a peaceful way, so you have to go past something before you can then log in for your work or something like that. That seems to me almost certainly in breach of the Misuse of Computers Act 1990 or something analogous to that. So I think it's quite difficult. I think, as you rightly say, Ruston, we simply haven't caught up yet. The new way of working, which most of us now have.
I mean, the thought also came through my mind earlier when we were talking about lockouts and the employer locking out. And I did then think of Elon Musk last week at Twitter, of course, essentially where employees found they couldn't get in to that. That's not obviously in the context of strike action, but that's the modern version of lockout, I guess, not being able to get onto the system. So I think, Will, we've got another question. I mean, nearly at time, but let's see whether we can have a go at it between us and come back. So thank you for the question. I'll read the question first of all. We are potentially facing strike action. We are a UK-wide employer. Could you give any guidance in relation to the differences between UK law and variances in Northern Ireland law? We understand ballot and turnout thresholds are different and there must be longer notice of industrial action. I have to confess, I think immediately, unless Will, I know, Will, you have some Irish heritage, but I'm not sure you're going to claim to be an expert on law in Northern Ireland. I mean, we certainly have contacts that could help with this. But Will or Stephen, either of you?
No, I'm not going to be drawn on Northern Ireland. It's its own place.
Okay. And the further question, what might happen if the TU notifies of UK-wide strike action but doesn't comply with the Northern Ireland variants of silence on those? Well, my high-level thought would be it has to get it right in relation to the locations that it's doing it in, if I put it in that way. You can't say that, well, because I've complied in Northern Ireland but not the provisions on mainland UK, that therefore it's okay in the UK. But I should think the contrary applies as well. In other words, and if there are longer periods in Northern Ireland, for various things, it won't be an answer there to say, but I've done it okay so far as mainland UK is concerned. But I mean, this is absolute, dare I say it, fertile ground in the context of challenge and potential challenge. I say to trip the employer, just frankly to make it more difficult for the trade union, and obviously perhaps at the same time as trying to push forward with trying to get some sort of settlements, at least through ACAS. And one of the things we haven't touched on as much in these two sessions perhaps we could have done is there's always there's a reputational piece, but there's also a whole PR piece so far as your own employees are concerned, for kind of almost who's behaving more unreasonably. And frankly, each side wants to point at the other and say that the trade union say it's the employer that's behaving more unreasonably, and of course the employer does that. And very often you have to be able to try and communicate directly with your employees and try and set the record straight so they actually know what's going on, because it's certainly my experience, unfortunately, that what can come out from certain trade unions can be very partial as to actually what's gone on, what the employer has said, what they've offered, what they've done, and action that they've taken. So I think if the individuals ask the question wants to get in touch, we're happy to try and help with that some more and liaise with some lawyers in Northern Ireland if that would help. So I think we've pretty much come to time because the final slide has been put up. So thank you, Amber. So thank you all for joining us today. Hope you found that useful. As usual, we'll pop the presentation on the website, and obviously if we can help further, then please do let us know. But we're just 10:30, so thank you very much and good morning.